Hello, everyone. So great to be here with you today, and so great to be here again with Paul Lewin. So, as you come in, please, we welcome you to tell us where you're coming in from. I'll take a few minutes to welcome you all. Please type in the chat as you come in where you're from, where you're watching this from, and we would love to see that. So I'm Dr. Pamela Crisco. I am one of the founding board members of the Psychedelic Association of Canada, and I am on the board right now. And this is pretty exciting what we're doing today. So thank you everyone for saying where you're coming in from. Really appreciate that. We're going to dive into this shortly, but I'm going to give you some information first just to allow everyone to come in and let us know where you're all coming from. We have a lot of great upcoming events at the Psychedelic Association of Canada. I'm going to let you know about them now. Going to let you know about them at the end of this. So we have an Ask Me Anything with one of our board members, Salme Tabrizi, a plant medicine deep dive. That's March 10th. That's members only. Really hope that all the members can join that. We're doing Ask Me Anythings with all of our board members over the years. So keep an eye out for that. We also have a fantastic session with one of the co-founders of the Psychedelic Puppet Show, Brad Nessick, and that event is called Dreaming It into Reality, Psychedelic Storytelling. And so check out the Psychedelic Puppet Show and check that out with Brad Nessick here with us on March 13th. And then we also have this fantastic Indigenous Wisdom Keepers series that is starting on March 10th. We have some of the wisest, longest experienced Canadians and North American wisdom keepers, knowledge keepers. So please make sure you watch for that. Our very first one will be March 10th, and that will be with Dennis McKenna kicking this off for us. So fantastic. Thank you everyone for joining today. Please, if you're just joining, put in the chat where you're calling in from or where you're joining us from. And with that, I'm going to start here. So Paul Lewin, thank you for joining us again. The last time you were here with us was November 6th, and you told us about this case that we're going to talk about today. And so what I'm going to ask first, can you introduce yourself? And then I'm going to ask you some questions so we can let our audience know exactly what's been going on with this court case, where it's going, and what we hope will happen. So over to you. Can you introduce yourself?
For sure. Thanks, Pam. My name's Paul Lewin. I'm a lawyer in Toronto. I was a long time ago criminal lawyer. I still do some criminal law. Have had a focus on cannabis, psychedelics, and drugs in general for many years. And I've kind of a focus on the Constitution and constitutional issues. So I've been practicing for about 32 years.
Right. Thank you. So let's start right at the very beginning for people that don't know anything about what's been going on with this. So tell us, why is there even a court case? So tell us what happened, why there was an arrest and what happened there.
Yeah. So my client, Samar Akila, he was a spokesperson for the Fun Guys mushroom chain. They're these dispensaries. They're big in Ontario, but in various parts of Canada. And he gave an interview on CTV News in a mushroom store in which he said, this is a protest and we want to change things. And they got the footage and they charged him. He was the only one in the store, so he had knowledge and control of the psilocybin in the store. And we challenged the psilocybin prohibition. He was charged with various psilocybin offenses, but the focus was you can't prohibit psilocybin, is what we said. And so this challenge, it was all about the psilocybin laws, and it wasn't really about Mr. Akila at all, is really what the case is about.
Okay, so walk us through that. So he was arrested. It went to court. What happened in the court case?
So in the court case, we challenged the law. So we said that the psilocybin prohibition is unconstitutional because it's contrary to freedom of thought. And freedom of thought, it's never been argued in Canada before. It's really one of the rare charter rights that's never been argued before. And we said that psilocybin is a freedom of thought tool. Just like you could say a passport's a freedom of mobility tool, or the printing press was a freedom of expression tool. It's something that allows you to experience the freedom more fully. And tools in Canada, under our constitution, tools are protected. Charter tools are protected. So this wasn't a weird thing to do. The real question is, what is it a charter tool at all? And I could put another way, really, what we're saying is we have the right to control how we think. That's what this was really about. But in legal language, it was all about its freedom of thought, was how we framed it.
So to give people, especially Canadians, a bit of more of a wider lesson on this, we have other charter rights, and other charter rights have moved us forward, such as I think cannabis. So tell us a little bit more about what other charter rights we have and how those have been used to advance society.
Sure. Yeah. So in the cannabis context, almost all of the cannabis cases have been under Section 7, which encompasses, and it's a law, it's a mouthful. I won't recite Section 7 to you, but essentially it protects reasonable access to medications reasonably needed. So just because it doesn't have a drug identification number, just because it hasn't been turned into a pill and authorized for sale, doesn't mean it's not medication that helps people. And so in these cannabis cases, they say, look, this really helps people, and there's these unfair barriers. And by the way, like I've been involved in this forever, and right in the very beginning, people talk about, oh, the government was so reasonable. They brought in medical cannabis. They never brought it in. They were forced. They were brought kicking and screaming. And that's the amazing thing about our charter is it's the highest law in the land. That means that if the government laws don't comply with the charter, they get struck down. And there is no law. And the government wants laws. They want order. So they will fix their laws to comply. And that's what happened with medical cannabis. They struck down the cannabis prohibition. And they said you got a year to come up with a system. And they came up with the medical cannabis system. And it was terrible and it took time, but really that's how we got medical cannabis, was fighting. We have other charter rights. We have, of course, freedom of expression, freedom of religion. But freedom of religion covers formalized religions, and there have been a couple cases that dealt with plant medicine or plant-based religions. And the law has kind of said that if just consuming a plant gives you religious or spiritual thoughts, that's not a religion. You have to have a funny hat. You have to have a few rules that go along with it. If it's just consuming the plant, that's not enough. And in a way, there's almost like a little gap in our charter that if I take something and I have important spiritual feelings from consuming a plant, and I really feel connected with my fellow man, I feel connected, I feel like I'm connecting with God, and I discover my place in the world, that's not protected unless I've got some formalized rituals around it. And that makes no sense. It's kind of like the spirituality falls through a hole in our charter, and in some ways, freedom of thought, it protects spirituality, which is kind of unprotected without freedom of thought. So that's kind of a quick rundown on some of the relevant charter rights.
Yeah, thanks. I think it's good to give that context especially because we have some visitors from out of Canada to understand that the reason cannabis is federally legal is because of a Supreme Court case in Canada. So it gives some context for that. So you went to court, the judge ruled against, which allowed this appeal. And this is quite significant. Can you explain what happened in that court case and why the way the judge made the decision opened the door for this appeal that we're raising funds for now?
Yeah. So the key part of the whole case was the judge's ruling that he had to define what is a freedom of thought tool. And he was a lower court judge. And it's kind of weird for a lower court judge to define what a charter right means. Like you never ever see that in court. There's always precedents for everything. Like you would never, in freedom of religion, a judge wouldn't make up what the rules are for freedom of religion breach. He'd refer to the many, many, many cases on this. But because we've never had it before, he was literally inventing the test right then and there. And the test that he invented was that in order to be protected, you must be able to predict the thought that you're going to get from that tool. So, and that's a terrible test. And the test I proposed was that you should be using it, it should be used reasonably for that thought purpose. So So I'll get back to his test. So he said that you have to be able to predict it. And the reason that's a terrible test is thought is so unpredictable. It's by its nature, it's unpredictable. We never know what we're going to think. And the example I gave and we talked about in the case a fair bit was a philosophy book. That's kind of a classic freedom of thought tool in which we would expect to use it for freedom of thought, for thought related purposes. But I don't know what I'm going to think while I'm reading it. I may be bored. I might not get it. Maybe I love it. Maybe I hate it. Like it's to, or a psychotherapist, you could say, is another freedom of thought tool. I go see a psychotherapist and I expect to change my thought for the better, but I don't know what I'm going to think. To say you have to predict your thoughts during the session, like that's ridiculous. And it's the nature of thought that we don't know how it's going to go. And so that's a terrible test. It would always fail. Thought that means a freedom of thought that there are no thought tools because they all will always fail that test. And that's a bad test. And rather, the test I put forward was it should be reasonably used for thought purposes, which mean on an objective standard and with a certain level of importance to it. So it should be reasonably used for thought purposes, means that you should have some empirical reason to believe this is going to do this. If you say, when I drive my car fast, I have wonderful thoughts and I should be allowed to drive my car fast. Driving my car fast is a freedom of thought tool for me. And that's not, you're not going to establish that empirically, even if you testify and say, I feel that way. That's not a tool that's going to, no, you're not going to get a bunch of experts saying that it enhances our thought. And there should be an importance component too, that it shouldn't be just for trifling things. Like I'm more clear-headed when I have my coffee in the morning. It should be something serious. And, the evidence before the court was that for many people who use psilocybin, it's the most important experience of their lives, or one of the most important experiences of their lives. This is not a thing where I'm kind of a little more clear-headed. These are events that they remember all their lives. These are huge turning point events which change how they proceed. And that evidence was fully before the court. So that's why I say it should be reasonably used for that purpose. You shouldn't have to predict it. That's where it all failed, was the test that he came up with. And the evidence, by the way, the evidence was incredible. We had the great Professor David Nutt, who is probably the leading authority in the world on psilocybin and drugs in general. We had Professor Zachary Walsh from UBC, who was amazing. Even the Crown, even the government expert said that amongst the many thought-related effects of psilocybin is it can cause deity encounters. And he tried to make this as sterile as he could. But really, you mean I might encounter God when I consume this substance? Like that is a pretty amazing thought benefit. And so, like I think by any measure, this is a thought tool, a freedom of thought tool that brings about important freedom of thought effects. And he did find that it can be used safely, which is huge on this challenge because they tried to say it's so unsafe. Even if it is a freedom of thought tool, you should never be allowed to use it. And the judge, even though he had that terrible test for freedom of thought, he said it can be used safely. The evidence has established that. So really, we're actually a lot closer than it seems when you read the judgment closely. Thought really the risks and the dangers aren't an issue on the case. It's just, is this a freedom of thought tool?
So
So
it
that's my
feels, if yeah, and from our last conversation, what I really came away with talking to you is he really kind of teed it up for you, didn't he? Like this is almost a dream thing. He almost gave you the roadmap and also the tools to take it forward. So now you're taking it forward. The plan is to take it forward. This is why we're doing the fundraiser. This is why we've got the GoFundMe. Cheryl's been putting it in the chat already. We've been sharing it out. We really need people to share that out because the first step is the documents, right? It's a relatively large cost to get those documents, correct? So
yes.
do you want to tell us the process of that is? So, and then I'm gonna ask you a few more questions, but that's what the first part of the fundraising is for. We need to get the $3,500 to first get these documents because going to court isn't for free either, and getting the documents isn't for free. So tell us a bit about this first step.
Yeah, so actually the very first step is issuing your notice of appeal. So you have 30 days to do that, and that expired in mid-January. And I thought I'm protecting this, like even if I don't have a penny, I am filing this notice of appeal. We're not losing this window. So we filed the notice of appeal. There's various other administrative documents we have to file. Um, I my the time to order the transcripts, I asked for an extension to March 2nd. The idea is that the court that hears the appeal has to see all the transcripts from the lower court case. They have to see everything that was said so that they're not missing information that was said. And a court reporter has to prepare those and they charge money. Actually, a lot of the transcripts were ordered along the way as we went by the judge. So often this is a more expensive step. It's cheaper because many of them have already been ordered, and once they've been ordered, they're cheaper. But I do have the Court of Appeal expects me to order them by a certain amount of time, and that's even with that extension. That time runs out on March 2nd, and then once we have that time, we can keep moving forward. Like but that is a very, very near deadline in which they will call me to court and say that if you haven't ordered them, this should be dismissed. And we can't let it die too, because like one might say, well, I'll do this thing again in 2 years or something like that. But we have this incredible record. Like we all the evidence is there. Like to have Professor Nutt was on the stand for 3 days. Like that's having Professor Nutt on the stand for 3 days. Like there's so much amazing evidence there. I don't want it to all just disappear. It can, and a great finding too is the judge said there's an exemption section in the Drug Act in which you can ask for an exemption, Section 56. Some of you may have heard of it before. And they always use this in drug challenges, drug constitutional challenges. They say you can just apply for an exemption. There's no problem with the law. And even if there's hundreds or thousands or tens of thousands or hundreds of thousands of people who want to use this and they don't even know where to go find it and they don't know the process, you don't know what has to be sent to the government. Like no one knows what you're supposed to do to get a 56 for freedom of thought purposes. Like and the judge, and by the way, the Health Canada witnesses who came to court, they were so hostile to psilocybin. It actually helped me because they were so rotten about it. And I said, if I wasn't a lawyer, how would I know how to do a Section 56? And one of them said, we're not in the business of telling people how to access illegal drugs. Anyway, the judge found, and like the whole idea is that they were not illegal. And the judge said that that's not working. That's not a viable exemption. And that's amazing too, because that's like one of their core arguments is you can always do that and the law is fine. So him finding that is really terrific. And also we were kind of blessed with these hostile witnesses, which actually worked for us. If they were more reasonable, that would have been more problematic. But bless Health Canada's hearts there. They came to court and played their role. So
Well, and it's interesting you say that just to give context, because I am a physician. We have worked very much with the Section 56 exemptions prior to being pushed back to SAP. And we worked with Section 56 when for clinical trials. And I can absolutely say, I think somebody put in the chat that they're getting harder and harder. And the bar has even moved for special access. So doing these applications from, 2 years ago, Health Canada has moved the bar continually and made it harder and harder. So it is, in fact, not an easy way for Canadians to get access to these medicines at all. So I'm glad that they were hostile because that's kind of the experience that we physicians are getting too from Health Canada when we're trying to help our patients get access to treatment. So.
And you mentioned physicians trying to get access. You know this well, and many of you know about the special access program, and it's getting harder and harder to get access. And freedom of thought, like whether or not of course, I talk a lot about healthy people getting access, but everybody gets access, healthy or not healthy, if we're successful. And even people who are struggling to get into the SAP would be able to get access under freedom of thought. So it really will benefit the well and the unwell. I mean, I think we're all unwell to some extent. Like it's not a thing. I don't know if anyone's really well, but it will benefit everybody.
Right, exactly. So tell us now. So we raise the money, you can get the documents, and then what are the next steps? What are your next steps with that?
So the next steps would be I put together an appeal record and I put together a factum. At the Court of Appeal, the factum is really the big document. That's where you weave together your legal arguments and your factual arguments. Um, and that's really your argument. And I will make this available online, my factum, so everybody can see what's going on. The appeal record is less, it's just a bunch of documents put together. I'm gladly make all of that available. Everybody should know about what's going on with the case. So this isn't going to be like a secret thing that's done. I'm going to be totally transparent, especially given the fact that it's being helped by the Psychedelic Association of Canada and many people helping in small ways. So everyone will know what's coming. And then the government files their factum, their response. And we go before a panel of 3 judges, and we argue it. We're not given much time. I'm going to ask. There's limits on factum sizes, but there's just so much to say, both about freedom of thought and about psilocybin. I'll say one more thing, and I'm sorry to just go off on a little tangent, but the Psychedelic Association of Canada framed it as the right to control your own mind. And one of the things that the judge found was he had a very narrow definition of what thought was, which is really quite, when you think about it, it's really nasty. And I won't describe it, it's like a mouthful, but it talked about requiring to come up with intellectual content. So some thoughts aren't sufficiently intellectual. Like if I'm just feeling happy or mad or grumpy or sick or mean or kind, like it doesn't matter if it's intellectual. It doesn't matter if this is some important thought. It's my thoughts that I can share or not share. And as part of his definition, you had to come up with an idea at the end of this. And we had an expert on thought. We had a brilliant guy. And if you read the transcripts, there's a gentleman, a professor from Dartmouth University in the States, Lucas Swain, who's like one of the leading thinkers on what thought and freedom of thought is. And he said it's mental activity and that we can keep it private or we can share it. It's our own thing. And the judge had this narrow definition of thought, meaning that there's a lot of aspects of what we think that's not protected and is not private. And anyway, so that's a little tangent. It's a terrible, rotten definition of thought that the judge adopted. Um, so I,
But in the scheme of things, it's actually been a big gift, right? So maybe our kind judge was actually being kinder in a way by saying some things that you can dispute and you can move forward with. So are you allowed in your factum to add more than what you covered originally in your case? Are you limited to what you can submit?
oh, well, that's actually a really interesting question. So you are limited to what was called at the trial. So that's a pretty hard and fast rule on appeals. The idea is we don't want to relitigate things, but there is an exception. And the exception is that if something has come about after that it wasn't reasonably available at the time of the trial, then you can call it. And usually in cases that's very rare, but maybe a witness comes forward no one knew about. But in this case, actually, there's been a whole lot of research since then, too. And if I had the resources, I would contact Professor Nutt and I'd say, let's put before the court all the studies that have happened since then. Almost because there was already tons there, but it's like this message, like, what should I come back in another year with another giant trove of like, when is enough enough? And so if I had the resources, I'd do that. I think we have enough, and I feel very confident fighting with what we have. But we actually, every time I see a study that talks about these thought-related benefits, I say, shoot, I'd like to put that before the court too. So in this moment, those are if I want to be super ambitious, but I do feel great about what we have. Like I said, everybody said it, and so I don't think we need more really, actually. So.
Okay, so you go to the Ontario Court of Appeal. Um, So there's two options that'll happen here, right? You'll either win, that's what we're going to see happen, or you don't win. So let's take both those scenarios. I want to leave the hurrah moment to the second part, but let's say you go to the Ontario Court of Appeal and they side with the lower court judge. Then what? Can you does it is it a sure thing that you can appeal to the next level, or what are the options?
Um, yeah, so it is, and I will note that, and of course, anything's possible. I could lose for sure. I can't guarantee anything, but there's no way they're adopting the trial judge's uh, CIS test. Like that's not. They might come up with their own one because it's a brand new charter right. There's no way they're adopting that. But if I do lose, the Supreme Court of Canada would almost certainly hear this appeal. I don't want to have to rely upon that, but they deal with things that are novel, where courts haven't spoken on it, and this is the most novel thing probably in a very, very long time in Canadian jurisprudence. So this is to have a charter right that's never been fought before, fought with a pretty good evidentiary record, like a lot to work, a lot of meat on the bones. I would say it is almost 100% certain they would take on the case. So, but I
Okay,
don't
now
want to rely on.
let's go down that other fork. You win the case
Uh,
at the appeal court. What does that mean?
so if we win the case, then so the law would be struck down. And the government would be given a period of time to come up with a system for freedom of thought. So because the courts don't want anarchy, they don't want there to be no laws. So they would declare the law invalid, but they'd say we're going to suspend that declaration for probably a year so the government can come up with a system. So we don't know how freedom of thought would work. What do you have to do to get access? It would have to be, what do you need? Do you need a therapist there? Probably you need a therapist. Do you need a medical doctor or a psychiatrist? I don't know what tests they'd come up with. Trust the government to come up with a crummy test. But anyway, but they would have to come up with something. And I think at that point too, there might be like, I think there could be some like if the Ontario Court of Appeal agrees with us, even though they might suspend that declaration of invalidity, I think we could. There might be two things that could be done to force the government to take action and not wait longer. Like they'd have to come up with a system, but in the meantime, I think that there are ways to force the government to start permitting access in the shorter term. But to answer your question, yeah, they'd be given the time to come up with a new system.
Okay, and so a couple things here. So I'm going to deviate a tiny bit, but I want to come back to a different question. Is a number of years you worked with us at the Psychedelic Association of Canada, and we did a MORA, a Memorandum of Regulatory Analysis. Would that guide? Do you think that document that we submitted to Health Canada would guide how the government might look at this, given a win in the courts?
That was medical, so that was all about
Mm-hmm.
medical access. So,
Mm-hmm. Not necessarily then.
yeah, like I don't think you need quite the same barriers as you need for medical access.
Mm-hmm.
I'm not sure how they would approach it. They have to be
Okay.
responsive to what the court says, though.
Yeah.
So
Right.
if the court says certain people should have it for certain purposes, but we don't buy in for certain other purposes. So like the evidence on the different benefits were of varying levels of strength. Like spirituality the evidence was very strong. On connectivity, the evidence was very strong. Creativity, the evidence wasn't as strong. I could see the government saying certain types of benefits aren't as meritorious as others. I think spirituality would be a one that would be given great deference. Mindfulness, I'm not, I could see them maybe saying mindfulness is not but all you have to say is that I want to use it for this purpose. Like you don't, um, and one of the arguments at the trial court was they brought up a case from many years ago, actually, I was involved in which they were concerned about access. Um, like they brought up a concern that it's just going to be the Wild West and everybody can just get it and use it any old place. But the truth is, the judge said it was safe, but he said that would be in the context of like with a therapist with some level of supervision, preparation, integration, that it can be safe. He actually, anyway, so the judge said, so that's what it's going to be, is it will be with the therapist. And this will evolve. I know with the medical cannabis rules, the first version was terrible and the second version gradually got better. But the big change would be everybody can have access. Um, but it might be that first version might be that you have to be with someone when you do it.
Okay, so taking that forward, we started putting out the GoFundMe. So Cheryl's putting it in the chat for all of us, and we've been sending it out to therapists and saying this matters to you. So if this case goes forward, this could be, or do you agree? Am I saying, is this appropriate or accurate? I mean, that this could be the fastest way that therapists and counselors would be able to be working legally with psilocybin.
Yes, absolutely. That 100% that will be um it's no longer going to be just about like, do you meet that emergency standard under the special access program? People who want to use it for spiritual purposes will probably have to do it in the context with a therapist. They can't just do it at a party. Um, there will have to be some supervision, but then they can work with maybe people who maybe they're not they don't have a life-ending diagnosis that they're struggling with, but they do have serious issues and they can't get in through the special access program. But they can, they do want to use it for freedom of thought purposes. What was interesting, actually, I didn't know this before the case, was that a lot of the treatment for depression, success stems from having spiritual or mystical experiences. So that spiritual experience actually means that it's more therapeutic for depression. So the two are really entwined, and someone who maybe doesn't get to the SAP would be eligible under this, in which there's really no standard. Probably a few people, like if you have a psychosis diagnosis, you might be screened out. There would be a few people with certain conditions who would be screened out.
Yeah, we'd
Uh,
want to still keep it. I mean, it wouldn't stop people that work with it from ignoring their regulatory, what they need to do. Like it wouldn't allow doctors to not still follow good therapeutic and medical practices. It wouldn't allow therapists or counselors or nurses. Like you'd still have to follow solid, good clinical practice if you're working with this medicine. It is not going to make it a free for all that way. Otherwise, people will be losing their licenses. So,
Totally. Yeah.
yeah,
No, and I'll
that's
just follow up on that. Probably the term to use is I say with reasonable limits. So,
right.
but I do think reasonable limits, like within a couple of years, retreats will be, but retreats maybe in the company of a therapist. A therapist goes with people to a retreat, and then it's a little more economically viable. But yeah, 100%, Pam, that with reasonable
Yeah.
limits.
Thanks. And so for people watching, if you're a therapist, if this is something you're hoping for, please go to the GoFundMe, put some money in there. Any amount helps. And then forward it on to your colleagues, your other therapists, MD, nurses, counselor friends out there. Please, please, please forward it. Yes, even if you can't put any money towards it, even $5, forward it out there. Let's get this out there. We need to get it over the 3,500 so Paul can get these documents. We need to get that ASAP. The deadline is in early March. What is the actual date? Your
March 2nd, Monday, March
March.
2nd.
Okay, so we don't have a lot of time. We're not far away from that first goal post. And then as soon as we hit that, so Paul can get those documents, we're going to start blasting this to the moon to get it so that now we have the full court costs so that Paul can get this all teed up to so that we can take it to court. Well, so you can take it to court and we can be there cheering you on for this. So do you want to say anything before we open it up to some questions?
I'll say a couple of quick words. One is that
Mm-hmm.
the case was about psilocybin, but if freedom of thought is established, that this is like a legitimate purpose that people use psychedelics, then like that will apply to other psychedelics. And psilocybin was a great one because there's so much science on it, but it's coming for other psychedelics. And freedom of thought is actually in over 100 constitutions in the world. So, like, I don't want to be too grandiose, but like, this has just never been argued ever. And I know cognitive liberty. Some of you old timers probably know the term cognitive liberty, which is really what we're doing. We're saying you have a right to think the way you want. Like that's been around for a long time. And anyway, I think it's not unreasonable to think that if it happens here, it'll happen in other places.
Thanks. I'm reading through the comments. So if anybody wants to ask a question, please put it in the chat. What do you, I'll put a comment here. Maybe you have, or I'll put this to you. Maybe you have a thought on this, but what do you think about the fact that it is actually in Canada easier for somebody to get made than it is for somebody to get access to therapy with psilocybin?
Oh, yeah, no, that's absolutely insane. That's ridiculous. And without getting into the legal the side of it too much, it's really a two-step process winning the constitutional challenge. The first step is there a freedom of thought breach? And then there's a second stage where they can save the law because there's a good
Mm.
reason for the law. And we really need this law, even though it is breaching some rights and it's out of sync with our beliefs as Canadians. And when you look at the fact that people can access MAID, but you look at other things like you can go rock climbing, you can go bungee jumping, you can play football or hockey and get a concussion. You want to do that? You can do that. You can drive on the roads even though there's accidents every day. There, like this is we can do dangerous things. That's part of if we feel good about it, we're allowed a certain amount of autonomy in Canada. We say it's good for people to be able to do these things. So like, there's no way they're going to justify it on that second step. And also, they'll for sure fail because the judge said it can be done safely. So, like, there's really one narrow test we have to prove, and then everything else flows. It's kind of like a bunch of dominoes, and all the other dominoes have fallen down except for the first one. So, um, um,
Okay,
so
good. Here, I'm going to go on to the next one. Gordon asks, before you answer this, though, I have some thoughts here. What can us lowly non-lawyers do? What is your perspective on winning over the gatekeepers? I'm going to throw out a couple things there right off the bat and hand it over to you, Paul. Number one, let us get this fundraising. Let's get this to the court. We've got an open door here. Paul Lewin is going to take us through this open door. So let's make sure we've got the finances. Not a lot of money we need to raise. It's actually pretty moderate when you think about what is spent in the world right now on so many other things. So let's get there. So share it. The other part too is I think that we're ready now for media attention. So let's be sending this out to all the media sources and let's get some coverage. How does that land with you? Like I think this should start being on the front pages of all the legacy media, but also all the other long form journalism organizations in Canada, like the National Observer, the TAI, the Narwhal, like all these people that do really good, solid reporting, not just clickbait crap. Sorry, the junk writers out there. But so you can do that. You can so help with the case. You can share the case. You can share the GoFundMe. You can put it out to media. You can call your MP and your MLA and say that you support access to psilocybin. What else can non-lawyers do, Paul?
yeah, I mean, those are all great ideas. I'll just say this too. If anybody is doing something like that, like, feel free to just email me and say, I'm doing this or that, or like, I want to raise the profile of these issues. And any way I can be of assistance to raise the profile, I'm happy to do that, whether it's being more helpful in terms of making the information available or any other information I can provide. Those are all excellent ideas. I think everybody kind of like, there's legal arguments, but then you also, the judges kind of have to feel like, I think on some, I mean, they're bound by the law, but it does help, I think, feeling like Canadians are ready for it.
Well,
Uh,
and on that point, like what one of the big things we do at the Psychedelic Association of Canada is we meet federally and provincially every MP and every MLA who wants to talk. And I can tell you, as a physician who has talked to hundreds of politicians in Canada and across North America and in Europe, I have yet to meet anyone that is actually against access. They just simply don't want to stick their neck out yet. So when I ask them, what can we do? Like how do you get to change your mind on this? Things they have said that don't work. They said, these clickbait petitions don't work. They don't look at them. Phone calls work. So you pick up the phone, you call your MP, you call your MLA, you call the health minister. That works. You write a letter, that works. So we have a lot of power, and we probably lost the skill set of doing this a lot. So those are things that people can do if we want to move the politics and make it so that when the judge rules in your favor, that it'll be very easy for that to go to Parliament and for them to make a good, solid decision.
You know,
And by the way, yeah,
oh,
go ahead.
sorry, Pam.
No, no.
I was just going to say, and I've just kind of just coming to me now that maybe one way I could help, or if someone, I see some of the names offering, making comments, and some of these are very informed, knowledgeable people in this space. And if any of these people, like perhaps part of this, I think what's overwhelming is when you actually go through all the research, you're like, wow, holy smokes, there's tons and tons of support for this. And I think maybe I'd like to, if someone wanted to work with me to perhaps put this in some kind of form that would be available for all on some website or multiple websites where people can access this. If someone, it was asked what can be done that if someone doesn't have money and they're not a lawyer, but how can they help? And I know the people posting this really know their stuff. So maybe that's a little bit of a project that should be ongoing. I would certainly happily work with anyone who wants to do that because I think part of it is showing the evidence to politicians too, not just saying like your laws are bad, but why are they bad? Like read this massive amount of information and you'll see, but making it digestible.
Yeah, and that's again one of the things we do regularly at the Psychedelic Association of Canada is we do a synopsis for ministers, and it's quite easy, folks. And again, I'm going to go back to every time I finish before a meeting ends with a politician, I ask, how do you want to hear from constituents? And they say they want to hear from you. They don't want a form letter. I mean, we can do template letters, but you need to make them personal. So tell the story. Why is this important to you? Um, let's Doug's asking, are there corporate interests? Are there international donors who would benefit if psilocybin were legalized? What do you think? Do you think there's
I think there are. I've reached out to a couple. I'm not, the Psychedelic Association have been so amazing and they're really the pros and they do this so much better than me. I have sent out a couple of emails. I'm not exactly, I think there are. I'm not exactly sure who they are. That's a really good question. I'm not
well,
sure.
we're gonna help you with that. We're gonna send out regular updates. We're gonna keep sending out updates from Paul to everyone as well, and especially if you do donate even $5 to the fundraising, you're going to get regular updates from Cheryl. Cheryl's our amazing community manager at the Psychedelic Association of Canada, and we have other than Cheryl, everybody else here, including all of our board members, are volunteers, and our social media team, which is also phenomenal, are going to be blasting this out as well. So we're really going to be getting that out there. We're going to help you look, Paul, so you can lawyer and we can work on this stuff. Let's see. There's another question here from Brendan. What are the criteria that allow the government to make psilocybin illegal to start? It is irrational even in the context of Canadian mushroom species. Why are death cap legal? Why was it justified in 1983? Can the government make mushrooms can the government make marshmallows illegal?
Yeah, actually, that's a great question because it puts it in its context. We're not just saying, like, the real question is this because we challenged the prohibition, this absolute prohibition, which became law as a result of those conventions back in the 60s and the 70s. And it was just made, a crime. And no one really knew why. No one knew anything about it. And if you look at the case law, I have to do this. Sometimes I have people charged with mushroom offenses. And you go back to the case law in the last like 2, 3 years, there's a lot of talk about dispensaries, but if you go back 20 years, no one knows anything about it. They're like, well, I think it's about halfway between pot and cocaine. Like the knowledge of psychedelics would make every single person on this call cringe if you saw a judge dealing with these issues in court. Um, so um, uh, so anyway, that's and by the way, one of the issues we put in there is we also just point out that, like, as a matter of severity, it's a lot of you might know this. Professor Nutt has a multi-criteria decision analysis rankings in which they look at all the different substances, and mushrooms regularly comes out at the very bottom, and it's because people don't compulsively do it day after day after day. You can't, because you're just going to get stop getting high very quickly. And also for many different reasons, it causes very little harm. And so we also, this will also kind of just replace mushrooms in a different context in Canada, because we, like, aside from this constitutional issue, there's just a lot of information about psychedelics that shows psychedelics really do lots of great things and hardly any bad things. And we can make them get rid of the very few bad things they do with just having a few guardrails in place. So in many ways, it's actually even bigger than freedom of thought. It's just mushrooms generally aren't bad at all. And like, it's only good will come out of this decision. But I
Mhm.
do think the big hit has to happen, and I don't see how it can't happen.
Yeah, thanks.
Oh,
And
sorry, Pam, and I don't know if I addressed
yeah,
it. Oh, yeah, I think I did. My apologies for interrupting. I think I did. And there's no
no,
reason for making it a crime. No one knew why, and it was the drug war, knuckleheaded drug war that does more harm than good. I'll stop.
absolutely, absolutely. And Brenda's point is real. Like you can, amanitas are perfectly fine. You can order them off of Amazon and have them at your house the next day. And yet psilocybin mushrooms, which grow all over British Columbia, easily found if you're a knowledgeable mushroom forager in October, is how can it seems like the hubris of humans to make a fungi, illegal. A kingdom is illegal or a plant is illegal. It's we have a very bizarre. I think if the aliens were looking at us, they go, "What the heck is wrong with you? You have the oddest laws on this planet." I'll find you another question here, but thanks to Sean, who also gives a shout out to Erica Dick, Dr. Erica Dick, who is one of Canada's most phenomenal historians, actually the world's most phenomenal historians on psychedelics. Everyone should read every book that Erica Dick has ever written. She's a phenomenal writer, and we should really know our Canadian history. So, and we've had her as a guest a number of times at the Psychedelic Association of Canada. So you can find those webinars in our archives on the website. A number of people have asked, what's your email? We'll put that in. Is it okay to share your email, Paul? Because
Yeah.
Cheryl can put that in the chat for you. So thank you, Cheryl, for being so amazing today as usual. So we'll get your email in there. And then Derek's I think this is a question. Yeah. It is not possible to argue that the current, is it not possible to argue that the current Canadian laws restricting access to psilocybin are directly traced back to the 1971 UN Convention on Psychotropic Substances, which was strongly influenced by the US Controlled Substances Act 1970-71, which specifically prohibited, I think we've covered this in a few webinars too, so thank you, Derek, very thorough question. Let me see. I'm going to skip a bit here. Was the express purpose of restricting freedom of thought, was it the express reason was to restrict freedom of thought rather than actually protecting people from drug abuse?
Um, I think that no, I don't think the express purpose was restricting freedom of thought. I don't even think they knew that. Well, the charter only came in 82, but they're just painfully ignorant about psychedelics. So I think it's a drug of abuse. It's kind of scary. We're going to shut it down, and they knew nothing about it, and it causes more harm than good. Like, don't
Mm-hmm,
tell me putting people in jail for that and giving them criminal
mm-hmm,
records is a sensible answer. And by the way, I'll just quickly say this. I mentioned the experts. I see one of the witnesses in the case. I'm not sure if he wants to be identified, but we had some incredible civilian witnesses who gave just powerful evidence, which was accepted by the judge. And I really, like, I almost would choke up like thinking about their evidence. It was
Hmm.
powerful
Hmm.
evidence. It was amazing evidence. And I'm not sure if he wants to be identified, but there are some great civilian witnesses on the case too.
Yeah, and you had a huge list of witnesses, and you had to narrow that down, and you did a phenomenal job. It sounds like, and I'll go back to Dr. David Nutt if anyone's looking up wants to see his article that was published in 2010 in the Lancet, and that chart that Paul Lewin is referring to was republished again in The Economist, and so that's easy to find. And then we have a question here from H. Hannah. Uh, if this approach doesn't get it across the wire, the Swiss SAP model provides access through their national public health system rather than the regulator. It makes it a public health issue, not a regulatory one. In Canada, the regulator, Health Canada, is the gatekeeper. Would a shift to the Public Health Agency of Canada, PHAC, offer a different access process? Is it even possible to request such a shift?
Um, I think there is actually that's a big fundamental difference that currently under the Special Access Program in Canada, and I get that she's not saying keep it there, she's saying move it, but it's only for medical, it's only medical access for those with an emergency health issue, and it's a very they're dishing those out with an eyedropper, and the key issue that I say is that even whether you're unwell or well, it provides really important experiences for us that for everybody, whether you're well or not well, and it should not matter. Um, like that shift, it's not a jurisdictional thing. They don't want regular people to have access. And anybody who has used it even a couple of times, like so many people I've spoken to, actually, we had three civilian witnesses, but I've spoken to dozens and dozens of people about their experiences and such incredible experiences. And I know I have had incredible experiences. It's like you can't just look me if know something a thing or two about psychedelics. You can't look me in the eyes and not tell me you have not had very important experiences on psychedelics. And so, yeah, it's a lovely medicine, but it's bigger than that. So I guess I'm not sure I'm disagreeing or not with that point, but I think it's not a jurisdictional thing. They just have to come to accept that this is important it's more than a medicine, or maybe a medicine for everyone.
We have time for one more question, but before we get to this cool, I like this question and I think we can stick around, but I'm just going to point out a few things here. I want to thank all the volunteers at the Psychedelic Association of Canada. You are all wonderful people and you make webinars like this possible. Especially thank you to Cheryl, who is our community manager and is running this webinar for us today. She'll put in the chat again, the GoFundMe. Please go into the GoFundMe and throw a few dollars at it, or $1 million at it would be even better. We'd like one single donor. That would be fantastic. Hey, Paul. Share it. Please share it out widely so that we can get to the full amount. So Paul can take this to court and just be a lawyer, not worry about the funds. Upcoming events at the Path, we have an Ask Me Anything with Salome Tabrizi on March 10th, Plant Medicine Deep Dive with her. We have on March 13th, Dreaming It Into Reality, Psychedelic Storytelling with Brad Nessick. That is Brad Nessick of the Psychedelic Puppet Show. It's going to be a phenomenal session. And then we have an Indigenous Wisdom Keepers series that also kicks off March 10th. And our first guest for that is Dennis McKenna, and Jillian Maxwell, one of the board members, will be hosting that series. So quite thrilled. We have a lot of knowledge keepers and elders that are going to be joining us for these beautiful chats. But back to you, Paul. You're also an elder in this field too. So thank you for all you do. And there's a question from Violaine here. Here in Toronto, we can purchase mushrooms in dispensaries. I therefore have a hard time understanding your struggle. Access to psilocybin is not different from accessing marijuana these days. Please clarify.
Oh, she's saying, hey, you can just buy it at a dispensary. Why are we going through this big headache? That's a good point. And it is true that the unregulated or black market or whatever, or illicit market is thriving. It's thriving to an incredible extent. Actually, we had numbers before the court about the 2.5 million Canadians every year use psychedelics. That's insane. And everybody else is just like, yeah, it's kind of like everyone disregards the law to some extent. but I think the law should be changed. Some people do periodically get charged, or it's a door to opening more trouble. It's a tool to search more, but also
Hmm.
it should be
Hmm.
something that people should be very open about. It shouldn't be a hidden thing where therapists say, "Oh yeah, I did have access, but I can't tell anybody." Or I'd like to talk to my doctor or therapist about it, but I can't talk about it. We shouldn't be hiding about this. And it shouldn't be a secret, and it's wrong to criminalize it. And in fact, not just should be allowed, it should be protected, is what it should be. It's a special thing that should be protected, and I think the charter will be protecting it.
But it's even a little bit bigger than that, Paul. Like if you have the privilege of living in Toronto, and the police are not, you know, doing anything about it, then you can buy mushrooms in Toronto. But that doesn't mean that you can get them in Moose Jaw, or you can get them in, Tabor or Prince George. I mean, you probably can, but I'm just saying that, the bigger cities, Vancouver certainly has dispensaries too, but they're all operating illegally. They're not, these are not legal dispensaries right now as the law stands. What they are doing is they are breaking the law. And so this case is about getting rid of that so that people have access to these mushrooms and are don't have to be in the roulette wheel of, are they going to be the one that gets arrested because they happen to be the one that buys the mushrooms, or buying them online. Like the other part of regulation also means responsibility, because I mean, we know from an Amazon study that a very high percentage of Amanita mushrooms purchased off of Amazon also had deadly poisonous mushrooms in there. And so there is also a level of ethical people that actually follow regulations and actually are selling what they actually say they are selling, can happen, and not just the economic opportunists that jump into this field and go, I can make a lot of money. So anyways,
Yeah, no,
there's some
absolutely.
more things there.
Yeah, oh yeah, yeah, and as well, there's people who are new to it who do need a little help or guidance. But anyway, there's 100 different reasons why that's
Mm-hmm.
an absolutely terrible law. Um,
Mm-hmm. All right. Okay. So we're going to support you on this. We are going to get this out as far and wide as we can with the help of everyone that's watching. If you guys all send it out to 10 people and they can send it out to a few more people, we're going to have this fundraise in no time. We're going to keep everybody updated on what's going on with you, Paul, and how this is moving. Um, I can see Jill has a question about SAPs. We're gonna point you to some of our other webinars on the website, Jill. We've covered SAPs there. You'll find a lot of great information, exactly on how that works. We'll get you back as we move closer, Paul, so you can update us on where we're at. We've got your web or your email in the chat. And any final words before we say good evening to everyone?
I have a final word. First of all, Psychedelic Association of Canada, you guys rock. Thank you very much for doing God's work. Thank you all who have contributed or expressed support or want to help in some way or another. And if there's anything you want to know about the case or have suggestions about making more things more transparent, I'm happy to work with everybody. I can't be committed to this and not like view it almost like a mission. So I'm happy to hear from it. And any way I can be more transparent about the case, I will strive to be transparent. Thank you. Thank you all very much.
Thank you, Paul. Thank you so much. And this is going to end very, very suddenly. So everyone go outside, get outside in nature, have some fun today, have a good laugh. And until next time, thank you again, Paul. So much appreciation for what you're doing.